My name is Hillary Johns, and I am a member of the Beverly Hills Bar Association and our litigation committee. And we have a new presentation bi-monthly that is called the Litigators Corner. It is a very fun and interesting new addition to our presentations, and that is where we interview a litigator, several good ones to choose from, and get their insights on current state of the law, current events, practices, do's and don'ts. A few of them are going to have cases they remember and why they remember them. I'm very excited about it. We all are, because I think a lot of these litigators have a lot to offer us in terms of advice, wisdom, and just experiences that come with life that I think we can all benefit from. And our first speaker, and we're excited to present, is Mike Sohigian, who is the president of the Beverly Hills Bar Association. So Mike, without further ado, tell us about what you do, Mike.
Hillary, thanks for asking me, but I appreciate the opportunity. I am a litigator in sole practice. My practice focuses on business litigation, real estate, employment, and insurance coverage principally. But as a sole practitioner, I have done a wide range of matters over the course of my career. Some people call that door law. I take whatever comes in the door and looks like it has money attached. That's an important factor for all of you litigators out there. If you don't already know, don't take a case that you can't be sure will pay, or as sure as you can be. So I've done a wide range of matters over the years. And I only do litigation. I don't really do transactional work. But I'm a graduate of Hastings Law School back in the early 90s. And though it seems like a short time, it was a long time ago. So thanks again for having me.
So Michael, I know that we had talked a lot about your concerns about litigators and litigation in the COVID age, and us being social beings that we are, we litigators. What are your concerns, and what do you see going into the future that we need to be more aware of and more diligent about?
Well, Hillary, just speaking for myself, I'm a joiner. I'm not only the president of the Beverly Hills Bar Association, but I've been involved in leadership in my church, and my son is a Boy Scout, and I'm involved as an assistant scoutmaster there. I really believe in the group dynamic and that people are better together. And I see a lot of factors at work in our society that push people apart, and COVID is the latest and probably most severe, certainly the scariest of those forces. So, you know, the practice of law is associative. I have built my career through friends, colleagues, opposing counsel, people that I know or have come into contact with over the years. My practice tends to be, the way that I litigate, I can open a book and do legal research, and I know the Code of Civil Procedure and can do all of those tactical things, but really my focus is always on the people and the stories involved, and trying to understand the facts, as conflicting as they may be, by bringing to bear my own understanding of human nature and how people behave, and trying to make the story that I tell from my client make sense in terms of what a jury or a judge understands of human nature. And I think that's pretty common with litigators. It's really more about telling a story and about the people that are involved. So I worry that we have this society which is more and more about remote, virtual experiences. And now, COVID makes it medically necessary for us to, for you and me, for example, to do this interview sitting in our offices, on opposite sides of town, using this technology. And we will probably be making court appearances, taking depositions, even to the point of having a trial using this sort of technology. And you and I talked about, how do you impanel a jury over Zoom? And how do you reach the jury and tell the story that you want to tell them when they're watching witnesses testify on screen and exhibits being shown on a screen, maybe with an Elmo or whatever the latest version of that is. I know you as a trial lawyer, what do you think the future holds?
Well, I agree. I mean, I'm concerned about the human element. There is, I had a hearing the other day where our client was terrified and she was able to handle it because she felt there was a buffer because of the technology. So I think a lot of people in civil matters, I don't think the Sixth Amendment has the confrontation clause allows it for civil matters. So I think, that thing where, we've all heard, I want to look this person in the eye. I want to be in the room when that person's deposed. If this person comes into the courtroom, I think they're going to freak out. I think we're going to be losing because I think it's going to change the dynamic. And I'm concerned people will lose touch about some of the essential tenets of our court system that they feel they have a right to engage in.
Yeah, Hillary, I agree. I worry about what the future of associations like the Beverly Hills Bar is going to be. Who knows, in 100 years, humans might be comfortable making deep, meaningful relationships with people whom they only see on a screen or in some holographic form. But, right now, I think we are really reliant on being in the same room with the person, having some kind of proximity and closeness in order to, really have a meaningful relationship. And those kinds of relationships, whether they're educational or professional referral relationships, it's very important to actually know the person, especially in the context of our profession, where if you as a lawyer refer a potential client to another lawyer, you are really giving your seal of approval to that person. And you need to know that the person is not only competent, but able, somebody that the client will feel comfortable with, somebody who can handle the ups and downs of typical high pressure litigation. And so you really need some experience with that person. And I just wonder how that's going to go. But that was an academic concern until just 3 months ago, because you could go all virtual or do everything the old-fashioned way if you chose. Now it's a matter of physical health, and for some people, life and death. We are not able to be with other people, and if that persists, I think we are going to have to really reimagine these personal service professions. It's not just us. I mean, it's architects, it's doctors, it's of course healthcare professionals, psychotherapists, psychologists, all that sort of thing. Those are all the client experience is about being with the person and working with the human nature. I have been talking about it in terms of concern and worry, but I think it's going to have to be addressed. We just have to see how it goes.
No, I agree. I think a lot about going into a courtroom and what we'll be missing because we won't be able to do that. Because even if we have sort of a pan of, I know we've had conversation, you and I have and the bar have, about, for example, how do you conduct a deposition and tell if someone's off screen making signals or kicking someone, or even just not just the human interaction, but how we're going to practice, and how much are we missing by just how much is this becoming? Is video Zoom becoming the boob tube? I don't know. I mean, I think for some people it already is. I'd like to think it's not any lawyers we know, but I mean, I think there are a lot of people just tuned into their machines, and how are we going to see the world differently? Because lately when I go outside, it's like, wow, hey, I'm out. Well, Michael, what would you say, not always our president, but as someone you've been around for a while, what would you say about litigators going forward in the future?
Well, Hillary, as you know, and lawyers understand, the courts of appeal defer to trial courts on factual determinations. And the reason for that is that the courts of appeal recognize that the trial court, the jury, the judge, were in the room with the witnesses. They had a chance to physically review the evidence. They have an understanding by virtue of that personal experience that allows them to make determinations of fact that the Court of Appeal, which is presented just with dry text and even possibly video, can't do. And that's built on an assumption that there are intangible parts of the experience in trial that allow people as humans, as human beings, to make some determinations about credibility and what is more likely than something else that you can't do virtually. So, we're going to have to address that in whatever kind of reformed process is put in place. We need that. The system is really based on that. Otherwise, everything becomes like an appellate proceeding. So I think probably, as a practical matter, as a just nuts and bolts seed, you'll probably see plexiglass shields between jurors. You might see plexiglass shields around counsel table. There'll be a lot less, as you and I were discussing earlier today, there'll be a lot less approaching the bench. And under some circumstances, maybe if you are approaching the bench, you might have to wear a mask. Maybe if you're at counsel table, the judge will allow you not to do so. Judges will have a lot of discretion, I think. It might be that we'll see different solutions in different places, different courts, different judges, and we'll just have to see what works best.
Or move towards what I know we've talked about in certain industries, like the entertainment industry and others. Is there going to be a uniform code of conduct that everybody is going to look to? So, Michael, I have a question. The reason I've thought of this is because I was in an administrative hearing last week, and a client of mine was just terrified to go. She was very, very nervous, and she actually felt better knowing that it was going to appear by Zoom, and that she felt she had this buffer between herself and the other parties and the attorney and even the adjudicator who was involved. Do you think we're missing a part of the essential part of the court process with the restrictions we now have or the human element?
I do. And I can understand why a witness would be anxious about testifying, especially in a highly charged matter where maybe the person who did something wrong is going to be sitting at the table. But I think what we miss and what the witness misses is an opportunity to present her case in a more persuasive fashion by being there, to communicate the facts, not just in the words that she says, but again, by the human element that she is able to convey to the other people who are in the room with her. That's an advantage, can be an advantage to the witness, as nerve-wracking as it might be. The ability to be there and have the intangible effects of presence can be to the witness's benefit.
And there are the other ones I think about. Sometimes people are not even watching the witness. After a while, they're watching the reaction of the other party who may be off screen, or they're watching the person after they've testified. Sometimes if they give a very moving testimony, for example, the jury sometimes just totally turns their attention to the victim or the person who's testifying, but they could care less what's really going on here. And there's mannerisms and facial gestures. Like, for example, you and I are only from our chests above on this, that we have no idea what we're doing with our feet, or if we're fidgeting our hands, or what we're doing. And a lot of that, I think, was it 70 to 80% at least of communication is nonverbal. And I think that people being muted and off camera, and if they're passing notes, they would have no idea what they're doing. Seeing that reaction, I think we miss that. Unless everything's on video and captured, and even then, if the lighting's not right, then you might miss something.
I'm speaking about things that really go beyond what you see. And I'm talking about things that we understand intuitively as animals that are not conveyed or that are actually sort of tamped down by having that buffer, right? A buffer works both ways. She has a Zoom buffer between herself and her the person who wronged her. But there's also that buffer between herself and the finder of fact, the administrative judge in your case, or a jury. So the witness may feel more comfortable, but she's also giving up something, an opportunity, the power to influence and persuade. May not be impossible, but that power is diminished by the buffer.
You can't have the presence unless you're actually there and everybody's in the room. Well, Michael, this has been so insightful and helpful. Are there any other parting comments that you would like to make, or points that you think you'd like everybody else to know? Because I know you've given a lot of thought to this.
Well, I think there will always be, of course, a need for lawyers. There is conflict inevitably in society. And we're the people who, for better or worse, are trusted by our clients to resolve the conflict, to advance the interests of our respective clients and have a judge or jury decide it. And very often, as a practical matter, we settle the disputes that our clients bring to us before a judge or jury ever has a chance to weigh in. And I think that will continue. I think what I would say as a parting word to whoever is watching this, lawyers and non-lawyers, is not to lose sight of the human quality, the human factor in the matters that we handle, even through the artificiality, through Zoom and screens, that behind that screen is a real human being who has emotions, desires, disappointments, frustrations, goals, dreams, and that's what we are dealing with. So it may be important now more than before to be mindful of that, because there are a lot of things that are present in our world now that might make it harder to keep that point in mind. And thank you again for letting me be the inaugural
Michael,
subject.
I really enjoyed this, and thank you. And you can take comfort knowing you were the first of many. We hope are many. So you will be our lead-off star, and we so appreciate your time and your support. Thank you, Michael.
Thank you, Hillary.